All right, let's start with that. You've been with the president for a while, and was it half meant when he was challenging, in effect, the U.S. on invoking the Mutual Defense Treaty?
Well,
or was it a test?
Well, let's say it was a bit sarcastic, but with legal basis. No? It was sarcastic because he was addressing the issue on the bigger perspective that people are accusing him of selling out to China. No? And that's why he said, well, I've had it with these criticisms. Let's let America walk the talk, and let's let them send the warships, and then we will support them. No? Why do I say that it is actually with legal basis? No? Remember, in 2014, we lost Scarborough. And we lost Scarborough because they sent at least 3 warships to the area, forcibly removed our Coast Guard and Navy from the area, as well as excluded our fishermen from fishing in the area. That, in my mind, is an armed attack. Also, China has built 3 artificial islands in what the tribunal, the ITLOS tribunal, has ruled is part of the Philippine exclusive economic zone, and therefore there is a military occupation of parts of our EEZ. No? And military occupations are always governed by the Geneva Conventions or the laws and the laws applicable in times of armed conflict. So if you want to be legally correct about it, we were a victim of an armed attack. The U.S. at that time...
You would consider that already, Attorney Roque, under international law, and also interpreting the Mutual Defense Treaty, you would interpret that as an armed attack?
Certainly, because an armed attack is sending off regular armed forces into the territory of another. No? And what did China do on the premise, of course, that Scarborough Reef is part of Philippine territory? They did send warships into the area, forcibly evicted us from the area since 2014, and we've not really been able to return to Scarborough in the same manner that we were in Scarborough before 2014.
But isn't an attack, I'm sorry, just to make sure that we're not missing out on definitions, wouldn't an armed attack be more provocative in its interpretation? In other words, someone who fires the first shot.
Well, a shot does not have to be fired, no? Because what is prohibited is the use or the threat of use of force. No? And in any case, there were actually armed forces utilized when they forcibly evicted us in 2014. Now, there's also the 3 islands, no? Fiery, Mischief, and I forget the other one, no? That is now being occupied by China. That by itself is governed by the Geneva Convention because there's a military occupation of an area which has been classified as exclusive economic zone of the Philippines by no less than the UN Tribunal for the Law of the Sea. So I'm saying it's both sarcastic and with legal basis, and the US and the Philippines president is basically saying, if you really want an armed confrontation with China, let's go, let's remove all this palabok, let's go to it. If you want an armed confrontation, you have a legal basis, do it, I'll support you. But meanwhile, since you're not willing to do it, please let me conduct my foreign relations in a manner that I think is towards or will benefit the Philippine national interest.
So you believe that overall, before the president said that, he actually looked at options, and that was one of the options.
Yes, and he's exasperated because he's in a position when he's trying to assert what is right for the Philippines, and yet there's endless criticism against it unless he actually goes back to the old policy of being 100% with the United States and even supporting the United States in a war for hegemony of the south of the West Philippine Sea, which Duterte has always said is not pursuant to the national interest.
Now,
we seek to gain nothing by supporting American hegemony in this area.
Okay, but you've also heard, last, I think it was July 4th, if I remember, the U.S. ambassador had a press conference, and he did reiterate the partnership between the U.S. and the Philippines, and the U.S. being there based on the treaty.
Well, that's precisely an issue that cropped out in the Supreme Court when we were arguing the constitutionality of the Visiting Forces Agreement. No? And I remember no less than Justice Carpio stressed that the Americans have been consistent in saying that although there is the Mutual Defense Treaty, it cannot be invoked for purposes of our ongoing territorial disputes with China. So for all intents and purposes, the MDT is useless insofar as the West Philippine Sea is concerned, no? As far as the American position is concerned. And yet, when it suits their benefit, they will say, oh, we will stand behind you because of the MDT, even in the West Philippine Sea. No? So there's no consistency in American proclamations. However, historically, take note that when we were a colony of the United States, the Americans never really considered the Kalayaan group of islands as being part of Philippine territory, or at least as part of the territory that they bought from the Spaniards.
Okay, moving forward, Senior Associate Justice Carpio actually gave President Duterte some no-war options in enforcing the Permanent Court of Arbitration ruling. Now, here are some of the options,
Yes.
because you were quoted as saying he should resign first before giving these options, but that seems like too late to
Yeah,
actually
he's
ask.
retiring anyway.
Yeah. No,
Yeah.
and not only that, he's already gone to court and won the case for the Philippines, and he was still a sitting Supreme Court justice then. Why did you say that first?
Well, in the first place, there
Because
is
you were quoted.
there is a canons of judicial ethics, which says that as much as possible, justices should not comment on issues that may be brought to them for judgment. And we're talking about agreements whose constitutionality may be questioned, so it would have been better if Justice Carpio waited for the right case to be brought to the Supreme Court, and there are cases which have been brought to the Supreme Court, and there he can say whatever he wants, no, as part of his decision or opinions. No. In fact, he has said a lot in many cases that I have brought to the court. I lost, but Justice Carpio was always a dissenter in the decisions where I lost, particularly on the validity of the Visiting Forces Agreement. No? Now, but my point is, sitting justices should not meddle with policy, unless it is part of their decisions. They can be involved in policy making, but as part of their functions in the judiciary. But let's go to the options.
Yeah, let's go to the options.
Justice
All
Carpio
right.
has suggested.
Let's discuss the options one by one, because they seem to be very good options. All right. His first option, the Philippines, Vietnam, Malaysia, Indonesia, and Brunei can enter into a convention declaring that, as ruled by the arbitral tribunal, no geologic feature in the Spratlys generates an EEZ, and there are only territorial seas from the geologic features that are above water at high tide. This convention will leave China isolated as the only disputant state claiming EEZs from the Spratly Islands.
Well, that's possible, but highly improbable. Why? Let me stress that the decision of the tribunal is none of the disputed features, is an island, in the sense that under the UNCLOS, an island is defined as capable of sustaining human habitation.
Yes.
When you're capable of sustaining human habitation, you can generate up to 200 nautical miles of exclusive economic zone. What the tribunal in fact said was,
You can talk
none
slower.
of them,
Yes.
none of them can create an EEZ, which means that we have narrowed the scope of the conflict.
Yeah.
At most, these features can generate only a 12 nautical mile territorial sea. Now, the problem is the Philippines itself is not ready to concede that all of the 8 islands that we are occupying are not islands. No? It is still our position that they are islands, either for purposes of generating EEZ or for purposes of generating territorial sea. Now, 2 of these so-called islands are actually reefs. They're underwater all the time. They're low water elevations. No? This is Ayungin, where we have an old ship, and then there's Rizal. No? I don't think we have considered that these are not even islands, or at least permanently above water, for purposes of generating 12 nautical miles of territorial sea. Now, even Scarborough, until today, we have maintained it's an island. Even if when you go to Scarborough, all you see is, rocks, basically. But we're still maintaining that this can generate 12 nautical miles of territorial sea. At the very least, although we're saying it forms part of our EEZ. Now, why am I saying it's impossible? Because outside of the Philippines and Taiwan, all other claimants to the West Philippine Sea only have low water tide elevations as supposed islands. So I don't think any of them will consider this point that these are not islands, more so that they cannot generate exclusive economic zones. And that is why, although it is possible, it's highly improbable. Because I don't think at this point that the Philippines will even maintain that Scarborough is not an island per se, no?
Yeah.
Although, really, it's just a rock.
Okay. So you don't think specifically Vietnam, Malaysia, Indonesia, and Brunei would go into that agreement, but they don't lose anything by going into that agreement.
Oh, they will, because if they concede that these features don't generate exclusive economic zones, then they will lose a lot of what they claim to be part of their maritime territory. No? I stress, only the Philippines and Taiwan are actually in occupations of features that are permanently above water. All other claimants have reclaimed them, their artificial islands, particularly Malaysia and Brunei. And yet, they're saying that they are claiming actual islands and not just parts of their EEZ. So it's impossible at this point for any of the countries involved in the dispute to concede this fact that they will only generate exclusive economic zones.
Okay, all right. Now, another suggestion, another option of Justice Carpio is to file an extended continental shelf claim in the West Philippine Sea beyond the 200 nautical mile EEZ off the coast of Luzon, where China is the only opposite coastal state. He says the Philippines can file this unilaterally.
Well, my opinion on this is it's impossible because the deadline has expired. There was a deadline for filing a claim for extended continental shelf with the Commission on the Extended Continental Shelf. We were in the UP Law Center, the integral movers of the Philippine filing for an extended EEZ. At the point when we were planning to file, I was saying we should file anyway for the Kalayaan group of islands, because even if there is a dispute and there is a rule that the Commission will not act on any submission where there is an ongoing territorial dispute, still, you have filed it for purposes of beating the deadline. But the DFA followed the advice of a foreign consultant and said that we could still file it later on. I mean, to me, as a lawyer...
But maybe it is true. Why would Justice Carpio make this suggestion?
Well, the point is, as a lawyer, when you have a deadline and you don't meet the deadline, you've missed the deadline. So far, we only filed for Benham Rice, no? I don't even know if we filed for Scarborough. I don't think we even filed for Scarborough because we identified initially 3 areas where we can make the filing for an extended continental shelf: Benham, Scarborough, and Kalayaan. But because we failed to file for Kalayaan, I don't think we can do it again. Now, having said that, even if we do file, for as long as the territorial dispute is ongoing, there is a rule etched in letters that the Commission will not act on it unless the territorial dispute has finally been settled.
But then, is there no other way to file it even after the deadline?
Well, my personal opinion is that's how deadlines work. You know, remember, the Philippine law is not recognized all over. In Philippine law kasi, we have some kind of liberality. No? Sometimes there's jurisprudence saying if a deadline is just for purposes of it, well, you should give the substance more weight and you should allow it. But under English law, for instance, if the deadline is at a certain date, at midnight of that certain date, you don't fulfill a prestation, then you've missed the deadline. So it's not true that...
it's open.
That it's open.
It's open. Because the way the suggestion, the recommendation is it seems it can be done.
My suggestion then was to make the filing for the 3 areas, and because of the rule that they will not act on areas where there's territorial dispute, I was sure that the Commission will only rule on areas without dispute, which was Benham Rice. But what we did was we did not file within the deadline. I have serious doubts if we can file it now, after the deadline had long passed.
Okay. Now, another suggestion or option is the Philippines can send on patrol its 10 new 44-meter multi-role response vessels that were donated by Japan for the use of the Philippine Coast Guard. The vessels are ideal to patrol the EEZ in the West Philippine Sea to drive away foreign poachers. That seems basic responsibility, although we should be doing it already even without the suggestion.
Yeah, my point is we don't need anyone to suggest doing that because that's why we purchase Coast Guard vessels anyway.
But clearly they're not doing it.
Well, we are, except that there's 10 and then there's 2 more coming from South Korea, no? But you know how huge the area of West Philippine Sea is? We will deploy them to safeguard our fishing grounds, and we will also deploy our 2 missile-capable South Korean vessels, no? So it's not something that need be advised to be done because I'm sure the government will do it. No? That's why we are purchasing and procuring vessels in the first place.
Okay. All right. Now, another one is the Philippines can welcome and encourage the freedom of navigation and overflight operations of the U.S., UK, France, Australia, Japan, India, and Canada in the South China Sea, including the West Philippine Sea. He says the naval operations of these naval powers, which are in conformity with UNCLOS and customary international law, have increased in frequency since the 2016 arbitral award.
It's being done, so why should we even support it still, no? The point I'm driving at is if the...
Won't it help to support, frankly speaking, to reconnect with, to have our allies to stress again that we support it in a way, because you said they're already there, but to have more allies support you in a certain advocacy.
Well, I'm not saying we're not doing it, because we do conduct military exercises in areas which are disputed, you know, or at least in areas very near to these disputed islands, which means that we are supportive also somehow of initiatives to maintain freedom of navigation in these areas, on the argument that no state can make an entitlement or claim of title to these areas. But the point I'm making is, under international law, if there are states testing it and proving that it is actually subject to freedom of navigation, then that's a fact, whether or not the Philippines support it. Now, whether or not the Philippines will support it is an issue, again, of policy, better left to the chief architect of foreign relations, the president, or even Congress for that matter. No? But what is important to stress here is, number one, it's not just the Philippine action that will determine whether or not the waters are in fact international or subject to freedom of navigation. This is where UNCLOS as a restatement of customary law will come in. No? And
that's the right word, restatement.
Yes, restatement of international law will come in. So regardless of what states do, if customary law says that these areas are considered as international waters and subject to freedom of navigation, then it will be.
Okay, all right. Another one is the Philippines can send its own navy to join the freedom of navigation.
That's the same, actually.
That's the same. Okay. The Philippine government can support private sector initiatives to enforce the arbitral award. The most creative and dramatic way of enforcing it has been undertaken by 3 patriotic private Filipino citizens, which is, of course, Ambassador Albert Del Rosario, former Ombudsman Conchita Carpio Morales, and their lawyer, Anne Marie Corominas.
I don't understand why he singled out the 3 individuals, because all these 3 individuals, at least former Ombudsman and former Secretary Del Rosario, did was to attempt to enter China, no? Through Hong Kong,
but they filed a case.
Yeah, but the filing is
President
ridiculous. Why should we support that when it has absolutely no basis, no? I mean, China is not a party to the ICC. They're saying that a crime is being committed in Philippine territory, but then again, there's an ongoing dispute which has not been resolved. Remember, despite the judgment of the ITLOS,
what ongoing dispute has not been resolved? It's been resolved.
Of course not. That's the point I was about to make.
Oh, yeah.
The ITLOS,
explain that.
Look, International Tribunal for the Law of the Sea.
Yeah.
So what was submitted to the jurisdiction of the Law of the Sea Tribunal are issues relating to maritime territory.
Yes.
What is the actual dispute in the West Philippine Sea? It's islands. When you talk of islands, you're talking about a separate rule of international law applicable to the acquisition of territory, and that is the state that can prove the superior claim will be entitled to title over the disputed islands. Now, the problem with the islands is it can't be resolved by ITLOS because it has no jurisdiction. It does not relate to the sea. And secondly, it cannot be resolved by any international judicial body unless a state expressly gives its consent. The ICJ is there.
No, I wanted to ask you, Attorney, just to, I don't mean to cut you off, but wasn't it already part of the decision, they've declared already what is in our exclusive economic zone, and those disputed islands are within our exclusive economic zone?
Not all. The judgment did not include any it did not include any judgment on which state has the title to the disputed islands itself. It has not ruled that Kalayaan, or as we call it, is actually Philippine territory. It has not disputed that the biggest island actually is being occupied by Taiwan is part of China. No? All it has said is, number one, there's no legality behind the claim for historic waters, the 9 dash lines. Number two, that the 3 islands, the artificial islands that China built are actually part of the Philippine Exclusive Economic Zone. And even on Scarborough, the tribunal did not even say it was part of the Philippine EEZ. It only said that all states have the right to fish in the area.
That's quite clear.
So, ongoing pa rin ang dispute on the islands.
Yes, but then, for example, the dispute that we're experiencing right now is, for example, a basic question of, can China fish in our EEZ?
Well, you know...
What is your interpretation to that? I mean, it seems quite clear when you read the decision.
You know, there was no such decision that China is infringing on our exclusive economic zone as far as fishing is concerned. Because on Scarborough, they said that all 3 states in fact can fish.
That's quite clear.
Now, But the point is, ibang issue yung iniisip mo eh. Ini-issue mo is when
No.
it's exclusive economic zone, can you share it with others? And my
Yes.
position is, as a matter of sovereignty, states can in fact share what is deemed to be exclusive to them. Why? Because you're a sovereign state. You can decide in any which way you want. No? Ang aking comparison dyan, if you have food that's for you, can you share it with others? Of course you can, if you choose to share it. Are you impinging on your exclusivity? Theoretically not, because you are exclusively the owner of the food that you want to share with another. So ganun din yung comparison doon. But if you look at the decision, it has not resolved the dispute in its entirety. It has clarified issues which will help us in resolving the issues relating to specific islands that are being disputed by the 5 nation states.
So that's the difference between your argument and I guess those that already went to court is you believe there's still a dispute.
There
You
is
believe-
still a dispute.
No, in other words, in terms of law, there's still a dispute. So what you're saying is China still has some reason to believe it's theirs.
Well, I don't know if they cannot invoke the claim to historic waters anymore. But what I'm saying is, as far as the individual islands are concerned, you apply a different rule now. And the rule is the state that has the superior claim will be entitled to title to that island. And that's why, how do you prove it? Through what is known as effective occupation. And what is effective occupation? Evidence that there is a sovereign state in charge of a particular disputed island. Anong evidence yan? Building of military installations, granting of concessions, which all states have done. So ultimately, when there is a tribunal to resolve on which state is entitled to which island, they will have to go through the physical evidence of effective occupation.
All right. Thank you for watching. For more videos, subscribe to the official ANC YouTube channel and click the I button.